Welcome. So often we'll wait a few minutes for the room to fill, but at this point we'll wait a few minutes and the room will be overfull. It's fantastic to see such a great turnout this evening, and welcome. Let me get right to the point. Every author in the room, and there are a number of them, dreams of being in Andy Coan's position. To be the primary source of information and insight for the top story in the nation's news cycle every other day. And maybe every day. At every other law school, this would be the source of envy. But in this Arizona law family, it is a source of nothing but admiration and pride. Professor Coan, whose book will be formally released on January 15th, delivers to a hungry national and global audience a significant and timely study of presidential politics and powers. We do have a few copies of the book here early for sale after the presentation. I have been anxiously, during the day, I got my copy today and I've been reading through as time allows. The book is entitled Prosecuting the President: How Special Prosecutors Hold Presidents Accountable and Protect the Rule of Law. So even though it's not on shelves yet, it has already earned the acclaim of the country's preeminent executive powers scholars. The reviews are in, and they are great. In addition to calling it a vital resource for understanding the Mueller investigation, Harvard Law School professor Jack Goldsmith says the book does, quote, a great job of explaining and analyzing, and quote, the special legal and political challenges that special prosecutors present. And from Eric Posner at the University of Chicago, the book provides wise, nuanced, and urgent guidance in an era when the public is increasingly receptive to demagoguery at the highest levels of government. And today, just in, a review that I do not believe Professor Coan knows about. It is, the quote, the perfect book for the present moment. Prosecuting the President is magnificent. That would be Professor Dave Marcus. And for anyone who doesn't understand the laughter, just ask the person next to you. Professor Coan's work has also attracted significant interest in the popular press. His work having recently been featured in The Atlantic, the Los Angeles Times, the San Francisco Chronicle, USA Today, and next week, Andy will appear on MSNBC's Morning Joe and NPR's All Things Considered. And based on what's happened so far, I expect him to be and remain the country's go-to person in the weeks and months ahead. Here to guide the most interesting and current conversation I think you are likely to hear is Andy's con law colleague and friend, Professor and Dean Emerita, Toni Massaro.
Thank you, everybody, for coming. I think the first question has to be, Andy, when did you become a media monkey? Sorry, girls, it was meant to be a joke. His family's here. Please welcome the Coan family. More seriously, Andy's scholarship to date, he's widely known for his work on, among other things, a concept of judicial capacity. He's extremely well respected. And known for all kinds of work, but this area is a very small and somewhat untilled soil area of constitutional law. And so the first question that I'd like him to answer is, what's the motivation? What caused, he has another book about to come out. This one, what drove you to write this book now on this topic and to immerse yourself in this issue?
Well, I just finished another big project, the other book that you mentioned, and I was trying to figure out what what is the most important question that I can write about now? And at the same time, everybody that I knew seemed desperate to understand what special prosecutors are, how they work, and particularly they seemed to understand how an official that seems so weak on paper, the president can ostensibly fire them at any time, how an official who seems so weak on paper could possibly hope to hold the president accountable, and how we as a society could possibly have entrusted such a weak official with this high responsibility. And I did a little digging, and it turned out that nobody had written a book about this for a general audience. And so I decided to do so myself.
So in the big picture, his book starts with two quotes that I think frame really nicely the substantive debate that the book addresses. And it underlies that you're going to hear more about the role of the special prosecutor in American history and law. Here's the first quote. "I'm the only one that matters." President Donald J. Trump. Here's the second quote. "Whether we shall continue to be a government of laws and not of men is now for Congress and ultimately the American people." Watergate Special Prosecutor Archibald Cox. So let's talk now about how you think these two sentences, these two statements of principle play out in the book, these framing concerns. And let me put it this way, spoiler alert, is Trump the only one that matters?
Not yet.
That's succinct, all right. So explain, deeper dive into the basics of the office. Okay, everybody wants to know, even if you think you know, how are special prosecutors appointed?
So historically, special prosecutors have been appointed in a variety of different ways. Sometimes the president appoints the special prosecutor himself. Sometimes it is the attorney general, the president's lieutenant, who's in charge of federal law enforcement, who appoints the special prosecutor.
So talk a little bit then, depending on how they're appointed, about their supervision and their independence.
So again, this has varied a little bit over the course of American history. The first special prosecutor was appointed over 140 years ago, and the arrangements have changed over time. But in general, special prosecutors operate and always have operated with unusual independence from the usual Justice Department hierarchy, and usual independence specifically from the Attorney General and the President, and definitely outside the day-to-day supervision of the Attorney General or the President. That's really what makes a special prosecutor a special prosecutor.
Who can fire him?
Well, it's the Attorney General who has the formal power to fire a special prosecutor today. If the President wants to fire the special prosecutor and the Attorney General refuses to do so, the President has a couple of options. The President can either back down or the President can fire the Attorney General. He unquestionably has the power to fire until he can find somebody else who's willing to fire the special prosecutor.
More on that in a little bit. When you say special prosecutor, it implies some limitation on their authority. What's the scope of a special prosecutor's power?
Well, what really sets a special prosecutor apart from an ordinary federal prosecutor, apart from their role outside the day-to-day supervision of the Attorney General, is that they are appointed for a special and limited purpose. They are, in technical legal parlance, officials with limited rather than general jurisdiction. And specifically, they're officials or prosecutors entrusted with the power or the jurisdiction to investigate and potentially prosecute particular individuals or subject matters.
And that contrasts with a regular prosecutor in what way?
So, a regular federal prosecutor, rather, who's called a U.S. attorney, or prosecutors working in the U.S. Attorney's Office, have general or plenary jurisdiction to investigate and prosecute any crimes within their geographic jurisdiction.
All right, so the important thing here is that they have to have limited subject matter jurisdiction. Who defines that?
Under the current regulation, it's the Attorney General who defines the subject matter jurisdiction of the special prosecutor. Most recently, it was the acting Attorney General, Rod Rosenstein, who appointed and defined the Attorney General, or defined the jurisdiction of Special Prosecutor Robert Mueller, because Attorney General Jeff Sessions, then Attorney General Jeff Sessions, had recused himself from the Russia investigation.
All right. What are the, I mean, it strikes me that there are obvious implications of that, and both positive and negative. From your perspective, what are the, what's the fallout of having somebody whose jurisdiction is limited to a particular set of issues, and that's their substantive focus, and that's their procedural framework? What's the upside, and what's the potential downside of that?
So it has a number of implications for the way that special prosecutor investigations play out in practice. To start with, it means that a special prosecutor is responsible for creating an office, in effect a working prosecutorial office from scratch, for putting together office space, office equipment sometimes, for staffing the office. It often tips off the targets of an investigation in advance. Typically, the special prosecutor is appointed to investigate a high-profile issue or high-profile officials who are involved in widely publicized alleged wrongdoing. And unlike an ordinary prosecutor who often enjoys the element of surprise, a special prosecutor is typically investigating someone who already knows that he or she is the target of an investigation and might already be actively working to scuttle that investigation in some way or another. A special prosecutor also has to deal with challenges to his or her jurisdiction in ways that an ordinary prosecutor typically doesn't. It's not uncommon for witnesses subpoenaed by a special prosecutor to argue that the subpoena falls outside the special prosecutor's authority. And a special prosecutor can also develop a kind of tunnel vision, charged with investigating a particular person or investigating a particular crime. Can cause the special prosecutor to really focus in or lock in on a particular person, to develop what you might think was a kind of monomania. At least this is a charge which has commonly been leveled against special prosecutors historically. But the very most important implication of the limited jurisdiction that special prosecutors enjoy is that they are forced to conduct their entire investigation really out in the public eye, which gives the president and the president's advisors and friends and political associates a strong incentive to do what they can to undercut the credibility of the special prosecutor. On the other hand, it allows the American people to hold the president and his political allies accountable for their handling of the special prosecutor investigation.
So you're saying he sets up the office, he or she sets up the office of the special prosecutor. Is it incumbent upon that special prosecutor to make the phone calls and assemble the team and decide which people to put on the team and what expertise he or she is looking for?
That's right. This can be another advantage in some circumstances. The disadvantages of having to set up an office from scratch are obvious. It takes time, it takes effort, it slows you down at the crucial early stages of an investigation. On the other hand, the special prosecutor has the flexibility to choose her own team or his own team, to choose lawyers with specialized expertise in the subject matter that the special prosecutor is charged with investigating. In the book, I invoke the Silicon Valley business cliche that special prosecutors are in effect charged with designing an airplane while they're flying. That's the downside of being a special prosecutor, having to set up an office from scratch. On the other hand, special prosecutors, unlike ordinary prosecutors, get to design their own plane. And there are some real upsides to that too.
Is there the risk that they can be accused of designing their own plane to fly in a particular direction?
That has been a common charge historically leveled against special prosecutors, and it's definitely a point of vulnerability, political vulnerability for special prosecutor investigations.
We're going to come back to that. The structure of the book, I want to step back a little bit. Something that's a real contribution is that he marks out the history of the office. And so in part one, he talks about why this isn't, we're not writing on a fresh page. He opens with Nixon And that's, obviously he famously appointed an outside prosecutor when the evidence was beginning to mount against him of potential criminal conduct, and that became visible. Let me ask you about that historical example, and then we're going to go back even farther.
Sure.
Did President Nixon have to appoint a prosecutor?
Legally, he was under no obligation to appoint a special prosecutor, but politically, he was under intense pressure to signal his seriousness about investigating the very grave charges which had been leveled against the president's close advisors in the spring of 1973.
And I'm going to come back to this too again. Could he have fired that prosecutor he chose to put in that position?
So he had the formal legal authority to fire that special prosecutor, and in fact, he did exercise that authority, although he had to fire 2 attorney generals before he could find one, then Solicitor General Robert Bork, who would agree to fire the first Watergate special prosecutor, Archibald Cox. But again, politics kicked in, and the political pressure to signal that he was really serious about investigating these allegations, which the American public, or at least a large fraction of the American public, took very seriously, forced Nixon to appoint a replacement for the first Watergate special prosecutor. Leon Jaworski was the replacement. And of course, it was Leon Jaworski's special prosecutor investigation that ultimately forced Nixon from the presidency.
So we're going to come back to the Saturday Night Massacre shortly too, but I'm going to go back even farther in time. You alluded to this already. Share with the audience, who was the first special prosecutor?
The first special prosecutor was John Henderson, a former Union general and senator from the state of Missouri, who was known for his political independence. In fact, he cast the tie-breaking vote, or the decisive vote, against the impeachment of Ulysses Grant's much-loathed predecessor, Andrew Johnson, as a Republican from the state of Missouri, which effectively ended his political career as a Republican, but it did win him a reputation as someone who was willing to vote his conscience, and that seems to have been one of Grant's motivations in choosing him as an outside prosecutor to investigate a Republican presidential scandal.
What was that scandal?
That scandal was known as the St. Louis Whiskey Ring. It was a kind of kickback scheme, or basically a bribery operation, or conspiracy among federal revenue agents throughout the Midwest. Hundreds of federal revenue agents throughout the Midwest were charged with collecting a tax on whiskey, which is one of the major sources of federal revenue in the 19th century. But it wasn't just federal revenue agents in the Midwest that were involved in this conspiracy. They had a connection at the White House. Orville Babcock, who was Grant's personal secretary, what we would today call his chief of staff, and a much beloved protege of the president who had worked on Grant's staff since back in the Civil War.
So that's the first one. How did that one turn out?
Well, badly, in a number of respects. Ulysses S. Grant was a man of great personal integrity, but terrible judgment in his choice of subordinates, almost to the point of gullibility. So he had great faith that Orville Babcock, his personal secretary or chief of staff, was innocent of the charges leveled against him in the Whiskey Ring affair. Really, very, very clearly wasn't. But Grant seems to have been bamboozled by the smooth-talking Babcock into first firing John Henderson after Henderson made some ill-advised remarks suggesting that Grant himself might be involved in the conspiracy. And then second, after Grant appointed a replacement for Henderson, and the heat began to turn up on Babcock yet again, Grant actually agreed to testify as a character witness on behalf of Orville Babcock in the charges being brought against Babcock by Grant's own Department of Justice. The only time it has ever happened in American history, and the result was a quick acquittal for Orville Babcock, one of the central figures in the Whiskey Ring scandal. And Grant basically escaped without serious consequences for these blunders, in part because he was a lame duck president nearing the end of his second term of office.
So we talked about whether to include the second one, and I can't resist. One more historical vignette before we turn back to Nixon, the Teapot Dome scandal, because I'm confident that everybody remembers this from social studies. And that presidential Rushmore also ran Warren G. Harding. That's as good as it gets in the presidential pantheon. Tell us about that one.
Well, Teapot Dome really should be better remembered. It is probably the single most audacious conspiracy or example of political corruption in American history. And it originated with a scheme among a group of powerful, unscrupulous, and ambitious oil barons and their political friends to buy the 1920 Republican nomination for Warren Harding, which they successfully did. The quid pro quo here, arranged with Harding's wily campaign manager and future Attorney General Harry Doherty, was that in exchange for bankrolling Harding's Republican candidacy, the oil barons would get to choose the Secretary of the Interior that Harding would appoint. And of course, the Secretary of the Interior exercises significant power over, among other things, federal oil reserves. The man they had in mind for that position was Jake the Oil King Heyman of Oklahoma. But Jake the Oil King did not actually survive to see Harding's inauguration, because when he announced that he was departing Oklahoma for Washington, his longtime mistress shot him. So the job and the dirty work fell to former Senator Albert Hall of New Mexico, an extremely colorful character, a living relic of the Old West, who is known still to sometimes carry a revolver in Washington, is rumored in his younger days to have disarmed a famous gunslinger in a Texas saloon, represented the man accused of killing Pat Garrett, the sheriff who gunned down Billy the Kid in the Lincoln County Range Wars. As you can imagine, former Senator Fall, was a guy who was willing to play ball. And the oil barons got the oil leases that they had bargained for, worth a collective nearly $10 million in 2018 dollars. Senator Fall got several $100,000, the equivalent of a couple of $1 million today, in exchange, which he used to expand his beloved ranch in New Mexico. And the result was one of the longest, and really historically one of the most important special prosecutor investigations in U.S. history.
And it's also going to be a film by the Coan brothers soon.
Coan, C-O-A-N.
All right, so that's a second, and the book, it's a fun book to read, Andy. That's a little achievement to add that color to it. As I said, the book begins with President Nixon, and you address Watergate, and many people, like me, that's the chapter that probably a lot of people in the room know best. But I know that there are some people in the audience for whom this is history they have read, maybe, and not lived. So tonight, tell us a little bit more about that chapter. Again, what was the Saturday Night Massacre?
Just to be clear, it's history for me too. The Saturday Massacre is the colorful name that a Washington Post columnist gave for the episode that I described earlier, when Richard Nixon fired the first Watergate special prosecutor, Archibald Cox, rather than turn over 9 secret White House tape recordings, which Cox had successfully obtained a judicial order for Nixon to turn over. And after firing Cox, or in order to fire Cox, actually, Nixon had to fire his then Attorney General, Elliot Richardson. He also had to fire Richardson's chief deputy at the Department of Justice, William Ruckelshaus, who was also, interestingly, the first head of the EPA. Back in the day, you could have environmentalists serving in a Republican administration in the House. Did great credit to the United States in both of those roles, maybe never more so than when he refused to fire Archibald Cox. But the president has the authority to remove the Attorney General, to remove the acting Attorney General, as William Ruckelshaus became after Elliot Richardson resigned, and he did so. Finally, Solicitor General Robert Bork, later nominated to the Supreme Court by Ronald Reagan, unsuccessfully agreed to fire Archibald Cox. And this decision was met with what can only be described as a firestorm of criticism, both from the press and from the public. Hundreds of thousands of telegrams, hundreds of thousands of telephone calls, hundreds of thousands of letters streamed into the White House, streamed into Congress. Nixon's Republican allies in Congress began distancing themselves from him, and the political pressure built very quickly, forcing Nixon to appoint a genuinely independent and credible replacement for Archibald Cox, which turned out to be former ABA president and Texas trial lawyer Leon Jaworski.
So there isn't constitutional text that answers the questions, or most of the questions here, with respect to how these things sort of proceed. But I think it would be fair to say that the Nixon episode has had a tremendous effect on how we think about these things, mistakes made, lessons learned. What do you think the major takeaways have been from in the aftermath, in addition to the ones that you've already named about political consequences of firing special prosecutors?
Well, for 2 generations, the Saturday Massacre episode has served as a cautionary tale for subsequent presidents, establishing a kind of political norm that firing a special prosecutor, at least absent some really truly compelling reason, is just beyond the pale. And that's been kind of taken for granted in American politics ever since. And I think that norm, despite all of Trump's railing against the Mueller investigation, despite all the criticism of the current special prosecutor, despite his reported attempts to remove Mueller at various points during the investigation, I think that norm established by the Saturday Night Massacre episode has played a really important role in protecting Robert Mueller's investigation. You've even seen many Republican members of Congress urge the president not to fire Mueller, pointing back to the Saturday Night Massacre episode as an illustration of what happens to a president who does try to interfere with the investigation of his own administration.
So he's outlined the basics of the office, the appointment, the scope of jurisdiction and limited power, and he's alluded to the vulnerability of the special prosecutor by repeatedly saying that he can be fired. Then we addressed some of the history of it, and there's more in the book about it, and I commend the book to you for that. In this last segment, I want to examine a few specific questions that come up in the context of the investigation in front of the American people now, the Mueller investigation. And here are some of the questions that have been given a lot of attention and that may end up mattering. We'll see. Can Mueller charge President Trump with a crime, assuming one has been committed?
So the short answer is probably not. And the principal reason for that is that the Office of Legal Counsel, a division of the Department of Justice, which has the authority to set policies for the department on certain questions, takes the position that the Constitution prohibits the indictment of a sitting president. So that position is controversial as a constitutional matter. I think there are credible arguments in its favor, and there are credible arguments against it. The main argument in its favor is that the indictment of a sitting president would interfere too severely with the president's ability to carry out his function. The main argument against that policy is that nobody, not even the president, is above the law. But regardless of the merits of this particular constitutional argument, the policy set by the Office of Legal Counsel is pretty clearly binding on Robert Mueller as a special prosecutor, operating under Department of Justice regulations. Press reports indicate that Mueller understands this policy as binding on his work. And so for those reasons, I think we're extremely unlikely to see Mueller file charges against President Trump during his term of office.
To be clear, you're talking about what the special prosecutor could do. What if the President of the United States committed murder during the course of his or her administration? Is it going to be prosecuted or indicted for a crime committed under those circumstances?
Well, murder, of course, is generally a state crime.
Well, right.
Not always a state crime, but generally a state crime. And it would, of course, raise special questions if a state prosecutor tried to charge the President of the United States, the sitting President of the United States, with a crime, tried to arrest him potentially, and incarcerate him pre-trial or to conduct a trial, which would result in a sentence of incarceration. I don't think anyone has, although this hypothetical is frequently invoked when this question arises, I don't think anyone ever expects a situation this extreme to occur. And if it did, I think there's a very strong chance that Congress would impeach the president in very short order so that the question would ultimately become moot. The Justice Department policy doesn't distinguish among different types of criminal charges. Although the optics of the situation, the pressures that might be brought to bear on the special prosecutor or on the Department of Justice more generally in that kind of situation might well overwhelm the letter of this particular policy.
We'll say that there's discovery during the course of this investigation of federal crimes. What about after the president leaves office? Could those criminal proceedings be brought in?
It's very clear that the president can be indicted after he leaves office. He may have various defenses at his disposal for acts undertaken during the course of his official duties that a court would have to evaluate in determining his guilt or innocence of a crime. But the law is very clear, Justice Department policy and constitutional law is very clear, that the president can be indicted after he leaves office. And Bill Clinton actually very nearly was indicted after he left office.
Could Mueller compel President Trump to testify before a grand jury?
The answer to this is not entirely clear. The closest Supreme Court case on point is United States versus Nixon, in which the Supreme Court ordered Nixon to turn over 50-plus secret White House tapes to Watergate Special Prosecutor Leon Jaworski. And what Nixon establishes is that the president can be ordered to turn over documentary evidence, whether that's an audio recording or written documents, when those documents are sought for use in a criminal investigation, and when the president fails to offer any kind of special justification, in particular, fails to offer any kind of national security justification for withholding. So we know that the president can be forced to turn over documents or tapes. We don't know if the president can be forced to testify in person. I think that the logic of United States versus Nixon holds for live in-person testimony in roughly the same way that it holds for written documents. But there is an important difference. The president can't delegate his own personal testimony to subordinates the way he can delegate the disclosure of or production of documents in order to testify either in some kind of out-of-court setting, possibly a videotape, in a deposition, or actually before a grand jury, or even before a petit jury in an actual criminal trial. The president is going to have to use his own time. The president's a busy guy, and the president is going to have to spend a lot of time preparing for that testimony, and that would presumably impinge on his ability to carry out his responsibilities in a different way than a judicial order to produce documents. Those practical issues, I think most people would agree, most people who have thought about this particular question would agree, can be surmounted. Several previous presidents have reached agreements with special prosecutors to offer live in-person testimony usually outside of an actual courtroom. I think in every case outside an actual courtroom on videotape, more like a deposition than live courtroom testimony. I suspect that a court deciding this question would look at those precedents and look pretty unfavorably at a presidential claim to be immune or privileged against that kind of testimony. But ultimately, I think most of these situations have been resolved outside of court through negotiation for a reason, which is that both sides have strong incentives not to push these questions to an ultimate judicial resolution. At least that has been the case historically.
So I think we're seeing that with Mueller too, in a lot of ways. Can President Trump here it is obstruct justice?
The short answer is almost certainly yes. The longer answer is that there are different ways to obstruct justice. Virtually everyone agrees, and this includes President Trump's Attorney General nominee, William Barr, who wrote a much publicized memo on this subject that was reported by the Wall Street Journal several weeks back. Most everyone agrees that the president can obstruct justice if he encourages a witness to lie under oath, or otherwise tampers with a witness, or if a president destroys physical evidence. The president can be charged with obstruction of justice based on that conduct. The controversy on this subject, such as it is, involves the question of whether the president can obstruct justice when he is exercising his official constitutional responsibilities, the ordinary duties of his office. For example, when the president decides to fire the FBI director, James Coan, can he be convicted of obstruction of justice or charged with obstruction of justice if he undertakes that decision, which unquestionably falls within the powers of his office, for corrupt motives or purposes, because he's trying to protect himself and his friends against a federal investigation? That's the question on which some experts argue, in particular, Trump's Attorney General nominee argues, that the president's Article 2 constitutional powers grant him a kind of immunity, an effective immunity from obstruction of justice liability, or should lead courts to interpret the obstruction of justice statutes as not applying to the president. I don't think that's the best reading of the Constitution or the best reading of the nation's obstruction of justice statutes. And I think there's a very clear historical precedent on this point. When Nixon was forced to resign from office, the final straw was what became known as the smoking gun tape, which was released pursuant to a Supreme Court decision in United States versus Nixon, a case brought by the special prosecutor. And what that tape showed was President Nixon ordering his chief of staff, H.R. Haldeman, to call the FBI and have to call the CIA, and to have the CIA put a stop to the FBI's investigation of the Watergate burglary and cover-up. What President Nixon was doing was exercising his supervisory authority over two executive branch agencies, the FBI and the CIA. It clearly falls within his Article 2 constitutional powers, but he was doing so, as the tape made very clear, for a corrupt purpose, not because there was a genuine national security risk if the FBI continued to pursue its Watergate investigation, but because Nixon was afraid that the investigation would turn up evidence of criminal wrongdoing by his closest advisors and cause grave political damage to Nixon himself. When this tape came out, the last vestiges of Nixon's congressional support completely disappeared. The House Judiciary Committee had actually voted out articles of impeachment against President Nixon a few weeks earlier, and in that vote, 13 Republicans had voted against impeachment. All 13 of those Republicans signed a letter after the smoking gun tape came out to say, whoa, this is new information, and on the basis of this information, we would change our vote. Nobody argued that President Nixon's constitutional authority under Article 2 to direct the FBI and the CIA made this something other than obstruction of justice. Nobody. And I think that's a very clear stroke of precedent, demonstrating that even when the president is exercising the ordinary responsibilities of his office, he must be subject to liability for obstruction of justice, even if he can't be indicted in court.
And I think it's an important question. Barr, who stands to occupy the office, does he disagree with that?
He disagrees with the last part of that analysis. And it's a little bit unclear from his memo whether he disagrees with it on constitutional grounds or on statutory grounds. His memo makes two different arguments. The first is that the federal obstruction of justice statute, which he assumes that Robert Mueller is proceeding under, is ambiguous, and because it's ambiguous, should be read so as not to apply, or as not applying or extending to the president, because if it were read as extending to the president, that would raise grave constitutional questions. Barr points to several Supreme Court authorities, which he says provide that in difficult statutory interpretation cases, a statute that could be read as applying to the president should not be read as applying to the president if that would in fact raise grave constitutional questions. He also seems to argue that the president has the Article II power to supervise the executive branch, and that no exercise of that power could be criminalized by Congress as a constitutional matter.
It's good to be king. And it's good to have that person in charge of the matter. And I think that's going to lead me, that's a statement you don't have to respond to. But let me just, to nail it down. So he can fire Bob Mueller, right?
William Barr, once he is confirmed, if he is confirmed, will have the authority to fire Robert Mueller. The current special prosecutor regulations prohibit the Attorney General from firing a special prosecutor except for good cause, which is a higher legal standard than it sounds like. It means basically a really good reason. But those regulations are not enforceable in court. Mueller would not have the option of seeking judicial review if William Barr thought there was good cause for removing him and Robert Mueller disagreed.
Okay. Now we've heard a lot about witch hunts. And you've alluded to the potential downsides of special prosecutors. And I will say, if it's a witch hunt, we have seen our share of brooms. But the concerns have been raised about the legality and the potential overreach of special prosecutors. Special prosecutors, are they unconstitutional, in your opinion?
No. I think it's very clear that special prosecutors are not unconstitutional, certainly not in their current form. And I think under current Supreme Court precedent, it's very clear that even a stronger independent prosecutor of the sort that existed from 1978 to 1998, some of you in the room will remember Ken Starr, others of you will remember the Iran-Contra investigation conducted by Special Prosecutor Lawrence Walsh. Those special prosecutors who served between 1978 and 1998 under a law called the Ethics in Government Act had robust tenure protection by federal statute. They could not be fired by the Attorney General but for good cause, and they could seek judicial review of the Attorney General's decision to terminate them. The Supreme Court held in 1998 in a direct challenge to the constitutionality of this law that these restrictions on the President's ability or the Attorney General's ability to remove the Attorney General were constitutional, were consistent with the President's Article II power. So I think there's no colorable argument under existing law that a special prosecutor like the one that we have today, who can be fired by the Attorney General without any judicial review, is unconstitutional.
And I would say the important thing is under the current case law that we have, obviously if the court were to adopt a different, more expansive view of Article II power, then it might change the landscape. But that, again, that's just a comment and not a question. I want to go back to you mentioned earlier that one of the risks of special prosecutors given this limited mandate is that there may fall prey to monomaniacal, attention. I'd like to call that the Moby Dick disease. When they go in search of the whale, they're going to find the whale, right? Okay. Do you think that that's what's happening with Robert Mueller?
I don't think that's what's happening with Robert Mueller, based on the best available public evidence. There's much of the evidence that you would need to answer that question definitively is not in the public domain at this point.
So when he finishes up, he finishes and he has recommendations, presumably, what happens, to whom do they go and what happens to them?
So under the current special counsel regulations, at the conclusion of the special prosecutor's investigation, the special prosecutor is required to submit a confidential report to the Attorney General. And it will then be up to the Attorney General to decide how much of that report, if any, to make public, and how much, if any, of that report to turn over to Congress.
So that decision will be Barr's appease.
If Barr is confirmed, that decision will be his in the first instance, although, of course, Congress has various tools at its disposal, and now we have a Democratic House of Representatives, which will be highly motivated to use those tools. Congress will have the authority to subpoena the report from the Department of Justice. That decision, if in fact the Department of Justice decides to keep portions of the report confidential, might be resisted on grounds of executive privilege. There might conceivably be a court battle. The House can also subpoena Robert Mueller, although there may be limitations on what he feels free to say in a hearing before the House of Representatives.
Wow. So that's a pretty vulnerable special prosecutor. And what good is this office if we're caring about the rule of law and potential criminal misconduct on behalf of the chief executive of the United States, and he hands the report to the president's appointee, who may choose not to release the information to the American people, and you have to just hope that the House is going to act. I'm bummed. What do you have to say about that? What good is the special prosecutor, and why did you waste your very young life? Remember, he wasn't around. Yeah. But Ursula wants to know.
So, special prosecutors can help the American people hold presidents accountable by raising the visibility of presidential misconduct, by acting as a kind of focal point for public attention and a catalyst for democratic pressure. It's a pretty remarkable thing, in light of the weakness that you just pointed out. It's a pretty remarkable thing that Leon Jaworski forced Nixon to resign the presidency. How did this subordinate official, who could have been fired essentially by the president at any time, drive the most powerful man in the most powerful office, the most powerful country in the world, from office? It's a pretty remarkable thing that Robert Mueller still has a job after almost 2 years, when press reports indicate that President Trump wanted to fire him. They even have issued an order to fire him as early as June of 2017. What explains that? I think the clear explanation is that political pressure, which is given a focal point by the high visibility that the special prosecutor brings to this investigation, political pressure has deterred President Trump from ending the Mueller investigation up to this point. Political pressure deterred Richard Nixon from firing Leon Jaworski after he got burned when he fired Archibald Cox. And political pressure is going to constrain, we don't know yet how effectively it's going to constrain, but it's going to constrain the behavior of whichever Attorney General in the Trump administration is charged with disposing of the Mueller report, whether that's acting Attorney General Matthew Whitaker or whether it's William Barr or someone else. Political pressure is going to be very intense. And even if the Attorney General decides in the first instance to suppress large sections of the report, political pressure has produced a Democratic House of Representatives which will be able to push back.
So 2 more things, and then we'll open it up to questions from the audience. One is, and you've written about this, so the left and the right in this era of tribal politics is waiting with bated breath to either condemn what Mueller does because he does too much, or condemn what Mueller does because he doesn't do anything. You've written a terrific op-ed in talking about why both of them will be wrong if that's their response. We want to share that with the audience for those who haven't read that. Terrific comment.
So, of course, we don't know what the Mueller report is going to say. And I think people forget this too often. People on both sides forget this too often. I think liberals tend to treat it as an article of faith, that if Mueller is allowed to complete his investigation, that he's going to produce a truly damning report. Conservatives profess to strongly believe in the president's innocence, but I think that claim is belied by their relentless attacks on the Mueller investigation. I don't think people typically, usually, try to destroy the person who they believe is about to exonerate them. So I think both sides really assume that the Mueller report, if it comes out, is going to be very damaging. And that might well be the case. If I had to place bets, I would guess that it would be pretty damaging. But we don't know that for sure. A lot of this is based on conjecture. A lot of it is based on speculation at this point. And I think if it turns out that Mueller comes up empty relative to expectations, if he comes up empty, particularly with respect to the president himself and his family members, and those high-level advisors who have not yet been either convicted of or implicated in crime, then conservatives, and the president certainly, are likely to be ebullient, triumphant. It's easy to imagine Trump's Twitter feed and his rallies, for the next few weeks, maybe the next few years after that kind of report comes out. It's easy to imagine liberals being completely crestfallen and feeling a great sense of defeat. But I think both of those reactions would be a mistake. I think that liberals would be mistaken because it will be a victory for the rule of law simply for Robert Mueller to complete his investigation. All along, the rallying cry of liberals has been and should be, nobody is above the law, and this is why we have special prosecutor investigations. And the completion of Robert Mueller's investigations, even the exoneration of the president, is exactly what the rule of law demands, if that's what the underlying facts dictate in this particular case. Now, won't this, in fact, be a triumph or a victory for Trump? And I think the answer is no, because the rule of law will have survived, if it survives, just by a hair's breadth, and despite the president's best efforts. And I think for that, whatever the contents of Robert Mueller's report, this president deserves lasting censure for the damage that he has done what ought to be nonpartisan ideals. And the irony of all this, of course, is that if there is no collusion at the end of the day, if there is no obstruction of justice at the end of the day, then the president could have avoided all of this damage to the rule of law, to his own administration, if he had simply allowed the Mueller investigation to run its course.
I think that answer goes back to the first question that I asked Professor Coan, which is what motivated you to write the book? And I think that is an eloquent, smart, and passionate defense of the rule of law and the role of the special prosecutor. What else, in closing, would you like to say to the American people about special prosecutors? What's the big takeaway? So I think it's implicit in what you just said.
Well, I think the biggest lesson of history and the biggest takeaway from the book is that special prosecutors are incapable of saving us from ourselves. That ultimately it's the American people who decide whether the president is above the law.
Thank you. take questions. We have just a few minutes, maybe 3 or so, and then there's a reception to which you're all invited afterwards. We will get a chance to ask Professor Coan questions afterwards. And thank you everyone for coming. So, Dean Miller.
In order to not waste time, I'll just speak loudly. Can you talk about the distinction between the House of Representatives and the Congress, the role of the Senate, in terms of what would happen if he tries to get rid of incriminating evidence?
So, the House and the Senate have distinct roles in the impeachment process. They have largely the same role in terms of legislative oversight of the president that takes place short of impeachment. So both the House and the Senate have the power to issue subpoenas for documents, for testimony, and if the Attorney General decides to withhold large portions or even all of the Mueller report, but either the House or the Senate could issue subpoenas to demand that evidence. The House is more likely to demand that evidence or to issue subpoenas because it's controlled by Democrats. In the impeachment process, the House acts like a prosecutor bringing charges. It considers articles of impeachment, and a majority vote in the House is sufficient to impeach the president. Impeachment is usually used or often used as a shorthand for removing the president from office, but impeachment actually formally means something like the bringing of charges, formal accusations against the president. And the House does that by majority vote. If the House votes to impeach the president, then the proceedings move to the Senate for a trial. And in the Senate, the president can be removed from office only if 2/3 of senators vote to remove him after the Senate holds a trial, which would be presided over by the Chief Justice of the United States.
Do you think there's anything distinctive that would be learned from the special counsel's report as distinct from the indictments, guilty pleas, documentary evidence that seem like they are coming out regardless of the report?
So I think Mueller is certainly aware of the possibility that portions of his report will be suppressed, and there's a good chance that he is taking a variety of steps to ensure that as much of the record in this case as possible is preserved and exists in some form outside the control of the White House and the Department of Justice. One way in which he already seems to be doing that is by using what are called speaking indictments in some of the early cases that he's brought against people like Michael Coan or Paul Manafort. A speaking indictment is one that includes more information than is actually necessary to establish probable cause for the charges which it seeks to bring against a particular individual. And the indictment, of course, becomes part of the records of the court, which is a separate branch of government from the executive and over which the president would exercise no control.
I have a question.
Oh, yeah.
Two questions, actually. The first is, as I understand the investigation of Donald Trump right now, is about what he did before he became president, before his election, as well as after. And we can get all of this information from what is going on with Manafort and Coan and Butina and et cetera, et cetera. Why can't Donald Trump be impeached or actually indicted, should the evidence show it, for things that occurred before he became president?
So,
therefore, there's no question of
so the Department of Justice policy against the indictment of a sitting president does not turn on when the alleged criminal activity took place. It's premised on the idea that the indictment of a sitting president would undermine the chief executive's ability to carry out his constitutional responsibilities, regardless of when the underlying activity took place. And so the Department of Justice took this position when Bill Clinton was being investigated for financial shenanigans in connection with the Whitewater land deal back in the late 1990s. That investigation clearly involved activity that took place before Clinton was elected president. And the Department of Justice's policy was, you can't be indicted for crimes that took place before he assumed office or crimes that took place after he took office, because doing so would bring the executive branch of the United States to a halt, and the Constitution exclusively entrusts that responsibility to the impeachment process and the democratically elected legislature.
That leads me to my second question. If what you're saying is true, what is the rule of law? And what is that concept? How does that concept apply in this case, where the Department of Justice, without any judicial backing, has established a policy that we are to follow as the people here? What is that rule of law? You know, actually you really haven't mentioned the rule of law very much, but I've noticed in a lot of the reviews about your book that you're saying that you don't like the rule of law process in this case, or you do like it. I'm not sure which is which. My understanding of the American judicial process is that there is no rule of law. That's why judges have always been given leniency to announce a rule of law and then speculate on whether it applies in this particular case or not, as opposed to for instance, the Napoleonic Code, which is in effect in Louisiana, in which if a statement of law says such and such, that is the rule of law.
So I think the distinction you're making is between common law systems
Yes.
And code systems. I don't think that distinction maps onto the idea of the rule of law or the ideal of the rule of law in any particular way. The rule of law is used in a lot of different ways, mean a lot of different things in a lot of different contexts. What I use that phrase to mean here in this context is the idea that the president, even the president, is constrained by legal rules that are not simply the product of his own discretion or his own imperious will.
But you're saying that the Department of Justice doesn't agree with you.
So the best argument, the best constitutional argument against the Department of Justice policy that the sitting president can't be indicted, I believe, is that nobody is above the law, not even the president. I think that is a strong argument. The question is debatable. I think there are good arguments on the other side. There are arguments on the other side that basically hold that we have different mechanisms for subjecting the president to legal control. We have different mechanisms for holding the president to account than we do other people because of the special considerations that his office entails. But we have some kind of mechanisms, and that's important. But regardless of how we resolve that question, I think at the end of the day, the special prosecutor has a vital role to play in providing the American people with the information that they need to hold the president accountable, that they need to decide whether the president has, in fact, acted in ways that are inconsistent with his oath of office and inconsistent with the legal constraints which we expect our public officials to operate.
Well,
So Andy, there are a number of people who have questions. The good news is that's a spectacular way to end a conversation. And I think we all understand, whatever our arguments and perspectives on any particular issue, that we're going to have our hands up going forward for some time. And at least we know who to listen for to help get some insights into the issues of the day. Andy, congratulations and thank you all for that.